The following program is made possible in part by the Dayton Bar Association.
Hello and welcome to You and the Law. I'm Mike Monta, the producer and host for tonight's program, and this is our first of the year 2013, so Happy New Year to everybody watching. And we're on for an hour. Don't change the station to watch the football game. It hasn't started yet, so if you're tuned in, keep on our channel. Topic for tonight is the public defender's role in criminal law and a review of some of the most recent notorious cases and upcoming laws. Joining me as guests on tonight's program, an esteemed panel from the Public Defender's Office here in Montgomery County, which is the second largest law firm in the county. Mr. Matthew Arntz is here with us, Mr. Chuck Grove, and Ms. Christine Communal. As I said, we'll be talking about topics of interest, and as we say on You and the Law, the best legal minds are here to answer your questions about the law. Before we get to our panel discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. There I am again. DATV is on Channel 5. It's the public access channel of Time Warner cable network here in Dayton. The program is also cable cast on the public access channels through the auspices of the Miami Valley Cable Council. Executive producer for the show is the originator of the program, former domestic relations judge Mike Brigner. Besides being on Channel 5, we do stream live on your computer at datv.org. This is an audience participation program. There's the number. It's 223-5311. If you have a question about our topic, and these fine folks can answer anything that you throw at them, please call in anytime while we're on. So, we're also sponsored by the Dayton Bar Association, which has been established in 1883, which if you combine all our ages, probably is more, 130 years or so. You got a math major here that can tell us how long they've been going. Anyway, they provide services. Bill Wheeler's the executive director of that organization, and they do a fine job for the lawyers and the community. So let's kick off by, see, I told you we'd get some football in. We'll give you updates on the game as they come. But first, let me ask our guests here on the program to introduce themselves more fully, tell you, the viewing audience, a little bit about their backgrounds and familiarity with tonight's topic. And I'll turn to an old friend of the program. You're all wondering who that is, but Matt Arntz. And Matt, it's good to have you on the show again.
Well, I'm a graduate of the University of Dayton School of Law in 1981, and shortly after that went into private practice. Concentrating on criminal defense, and was in a private practice for 30 years. And then 5 years ago, transitioned into the County Public Defender's Office. And I've been there about 5 years, and I enjoy it quite a bit working with these folks.
Okay, thank you, Matt. And Mr. Chuck Grove. Chuck, good to see you again.
Thank you, Mike. I too am a public defender, have been for 25 years now. Right now, I am assigned to felonies, which are the more serious crimes that the courts handle. But throughout my career, I have covered every case that can be imagined where jail is a potential penalty. Anything from no driver's license cases all the way up through murder. And I anticipate remaining on the felony division for a little time to come yet.
No one's asked for your resignation.
No one's asked for my resignation yet.
All right, and you have not tendered it.
And I have not tendered it.
So, okay, well, that's great. And we turn now to Ms. Christine Communal. And Christine, welcome to the show.
Thanks, Mike. Thanks for having me. I am a 1993 graduate from the University of Toledo School of Law. I started in the public defender office there as an intern while I was a student. All the public defenders up in Toledo work part-time, and I endeavored to be a full-time public defender and found a job here in the Montgomery County Public Defender's Office in 1994. Have been here ever since, enjoying what I do, have no intention of doing anything else. Very much enjoy representing the indigent population who are criminally accused.
Thank you. Welcome to all of you. Recently, within the past half year or so, we've had a lot of tragedy in our country to do with guns. And there are motions afoot in Congress and other places to either limit them, limit mental health issues. In other words, we got to stop people from getting killed at random by automatic, semi-automatic, and proliferation of ammunition. What do you all believe that the public defender's role is? Obviously, you're not legislators, but some of the aspects of your representation of people who are charged with gun offenses. Do you have any thoughts on that?
Well, I guess I'd start by saying that we're involved in defending folks charged with violating state and municipal laws. There is federal regulation of firearms, and then quite a bit of state regulation, which varies from state to state. So we're primarily involved with defending folks who've been accused of violating state of Ohio laws regarding the use of weapons and firearms. And Ohio prohibits the misuse of weapons and firearms with crimes ranging from misdemeanors to felonies. Felonious assault, using a firearm to cause serious physical harm to another person, that would be an example of a felony offense in Ohio involving the use of a firearm. Operating a motor vehicle with a firearm inside it can be a misdemeanor type of an offense. So those are the type of offenses range from misdemeanors to felonies that we are involved in, and some of it involves clarifying just what it is that our clients actually did or did not do with a weapon that was located at the scene of a crime, or even located in our client's vehicle or home.
The studies have shown that since some of the shooting incidents in the within the past half a year or so, or even farther back, that gun sales went up. Do we find in representing clients that people are trying to defend themselves more by buying more guns? Or is this just a sign of the times that the police and authorities can't stop it, so I'll stop it myself? I figuratively.
Well, believe it or not, Michael, there are times when some of the people that I've represented have actually violated the law intentionally. I know that comes as a shock to you, and I suspect it's probably the same in other jurisdictions. I don't think that there's any correlation between a new law and what some of our clients might do. A lot of our clients have, for years, used weapons to rob, burgle, shoot other people, and I've not really seen a strong correlation between changing the law and some of that behavior. I really haven't. We have already in place, I think, enough laws that when someone misuses a firearm, that we can prosecute them, and we should as a society. Society doesn't have just the right, but the duty to prosecute individuals who engage in horrendous behavior. And I'm not so sure that changing a law is going to change the behavior of some of the people whom we represent.
Have we noticed a difference in the behavior of, and I'm saying our clients, the criminal client, as opposed to 15, 20 years ago, that there's less regard for other human beings and the safety of society in their everyday movements through life?
Well, I can tell you my experience is that the culture in many of the areas in Dayton and other areas is that everyone has a firearm, whether they obtained it legally or illegally. I think they believe that they need to have that gun, and these aren't people who are generally following the registration requirements and the regulations in order to get that gun. These are people normally getting the gun on the street from pawn shops, things of that nature, where they don't have to go through all the red tape that we're talking about as far as gun regulation. So a new gun law or regulation, so to speak, to make the ability to obtain a firearm more difficult, I don't think is going to curb the weapons on the street and the gun violence.
Well, usually it's not discovered that you aren't registered until you are found out to be not registered. Would that be a fair statement?
Well, I'd echo what Christine said, because a disturbing trend I've noticed in recent years is younger and younger men carrying weapons and traveling with weapons. And they've said to me and said to judges in open court, you don't understand, I have to have this gun to live in my neighborhood.
Right.
Which is a really troubling thing to hear. But we hear it again and again.
I think I've noticed that when one of these catastrophes happen, that the media in general, after offering their sympathy to the victims of these crimes, want to know the reason why these things happen. What's behind it? Did he not get along with his mother? Was he mentally ill? Was he addicted to drugs? Things like that. Now, I don't think we've had one of these in Dayton, but in each one of these cases, when the person is apprehended, the general public wants to know what was the motivation, and I think this latest one in Connecticut, they've yet to determine a motive. What is the role generally of the attorney for these folks? And they're usually assigned an attorney almost immediately after they're detained, if there's not a shootout or something like that. Does the public's need to know clash with the defendant's right to remain silent. And our panel's right to remain silent.
Yes, yes. Well, I would say that technically, prosecutors are not required to prove motive in a trial involving a firearm offense. They're required to prove that you violated the law, even if they're unable to explain why you did it. As a defense lawyer, we often want to explain why something happened. And generally, we use one of two different kinds of defenses. One defense is a denial defense. In other words, we didn't violate this law. We didn't actually break the law. And the other type of a defense is what's called a justification defense. In other words, yes, I did use this weapon, but I was justified in using it under the circumstances. So a justification kind of a defense would be self-defense. I did use the weapon, but I was justified in using the weapon because I had to do it in order to protect myself.
Well, none of this applies to the mass shootings where people, doesn't seem to.
Right.
So does the attorney doing his job fall into the category of the second most hated person in the shooting right after the shooter?
Well, it's quite possible. I'd be one example of the most unpopular client, I suppose, that one could have. Nevertheless, when an individual is charged, I don't care with what, they are still entitled to a legal defense. And if we fail in that regard because it's not popular, then we are sure to be told we cannot use that same theory in other situations. It would be a slippery slope to start down to suggest that we should do something less than our best for an individual who is the most unpopular individual that you could imagine. And I would suggest that your example is probably the most unpopular person that one could imagine, an individual who would turn a loaded firearm onto a civilian population for no reason at all, or for any reason at all. You can't justify shooting into a crowd of individuals, be they adults or children. And I think that aside from all of the hoopla that we've recently heard of, oh, we need to change the laws again, as if somehow we're going to all of a sudden pass a law that makes crime illegal. We've seen how well that's worked in other situations. But you can't say, oh, let's give this guy a shorter bit of fewer rights. We have to actually make sure that even with the most unpopular, that we have individuals who will step up and to the best of his or her ability, defend this individual. Then if the individual is convicted, after the state has jumped through all the requisite hoops, so be it. That's the way it's supposed to work.
I think it was H.L. Mencken that said the laws are created for the worst offenders and the rest of us have to suffer through it.
Well, I've heard that many times from individuals who especially don't appreciate or understand really what public defenders do. Oh, you know, those people you represent, as if it's a broad indictment of everyone who is indigent and accused, and that's not fair. But you have to realize that laws have to have a benchmark below which you cannot go. And you suggested the quote, and that may actually have a ring of truth to it, that if you set it for any place other than that, you're making a tragic mistake.
I think when the people who commit the crimes, or especially when they are in the media, are apprehended, there's a desire to know right away what was behind this, what they were doing, how'd they get a hold of the guns, et cetera, et cetera. And I think we were talking before the program about getting to know our clients. And one of the first person who the perpetrator of these acts talks to is the attorney. Of course, the media is always surprised when a plea of not guilty is entered at the first arraignment. And I turn to Christine here because we talked about discussions with the clients. And what is it, in order to have a proper and adequate representation, that you are looking to talk with this type of person or any type of person about?
Well, by and large, Mike, you need to make sure that the first thing you do is instill confidence in your client. Let them know that what they share with you does remain in your confidence. You have this confidential relationship with your client, and you're not to share anything they share with you without their permission. So going back to your question about does the public's right to know clash with the attorney's representation of the client? Absolutely. If the public can find out through law enforcement or other investigation, that's fine, but it doesn't come from that accused attorney. But when you meet with your client, you want to find out who they are and what makes them tick, all of their issues, so to speak, and 9 out of 10 of my clients have issues, and many of them are mental health issues, substance abuse issues,
Economic sometimes.
issues, absolutely. So you want to find out who they are, let them know that you're there to be their advocate and that you're their confidant, and then talk to them about the issues in the case and the potential defenses to it, and the things that you're looking to do for them in hopes that you guys can develop a good relationship, work together, and make sure that they get the best defense that is possible, because everybody is entitled to that.
But it's true probably that when you meet with the client, especially a notorious client, right away, you're not thinking of solving the whole case or the panorama of defenses as much as finding out something about the person, have them maybe finding out a little something about you.
Right.
Okay. We're about 20 minutes into the program. We're going to take a brief break here. We have no commercials, so you have to listen to me for just a little bit. You're watching You and the Law here on DATV, Channel 5, and DATV.org. We're streaming. We're sponsored by the Dayton Bar Association. And Dayton Bar Association, as I said before, has been around since 1883, provides a variety of services for our Miami Valley citizens, some of which are a lawyer referral service. If you don't have an attorney and you don't qualify in a criminal case for a public defender, call the Bar Association at 222-6102, and they will assist you in finding a lawyer who would be adept at handling your case. There's also a notary public service. You want to become a notary, notarize all the licenses and stuff in your neighborhood. They have an applications and testing site, and they'll tell you how to do it. You got to study a little bit. You can't just go in and say, I want to be a notary. You have to pass a test. Wills for Heroes is another important program. Volunteer members of the Bar Association, working for nothing, create wills for emergency first responders, firefighters, police, and EMTs. Very worthwhile project. If you do fit into that category, I believe there is a session in January. I know there's one in February I don't know the dates. Call the Bar Association at 222-7902, I believe is the number, or call the other number. And they'll tell you when it is. And for a couple of hours, get a will for you and your family. Be worthwhile for you. There's a lot of community service projects. And there's Volunteer Lawyers Project also, where it serves the disadvantage of our county. So I've talked enough. Bill Wheeler, as I said, is doing a fine job over there with his staff. And we're happy to have them sponsor us so we can talk to you, the viewing public. We're talking about criminal law with esteemed counsel from the Public Defender's Office, Christine Communal, Chuck Grove, number 3, and Matt Arntz, number 1. I've just been handed a bulletin here, by the way, that Alabama has been disqualified from the BCS championship game tonight, and because they actually lost the game.
That was last year.
And they will be supplanted because Jim Tressel gave back the tattoos by Ohio State. And another bulletin which we just got indicates that Bull Bushka has scored Ohio State's first touchdown. They lead 6-0. The extra point was missed. And George Gipp fell on the ball, was thrown into the end zone for a 1-point safety. So the score in the first quarter is 6-1 Ohio State over Notre Dame. And our volunteers will give me more updates as we go along. So getting back to our program, and we were talking about criminal law and some of the disasters which have happened in the past year. And I wanted to talk about a tactic which may be used in these cases in the upcoming years if it passes our legislature, and that is the ability for the prosecutors to request that the cases be tried by jury. It's House Bill 265. You may have heard about it. Defendants are entitled to a jury trial, and we'll talk about their possibility of waivers and maybe in the future not being able to waive those. So what have you heard, and how's it going?
Well, my understanding is this is a proposal before the state legislature that is still in committee. This is not a bill that has been passed.
Been assigned a number.
Right, it's been given a number, it's being discussed and considered and debated. And by and large, I think this is the product of prosecutors throughout the state who would prefer to have some of the more notorious, celebrated, sensational cases tried to a jury.
And what's the theory behind that? Why wouldn't, I mean, it obviously saves time and money. In fact, there was a talk in legal circles years ago. Why do we have juries at all? Why don't we just try things in front of judges? Obviously, they know the law better than all of us around. And now this thought that, well, we don't want a judge to do it. We want all these serious cases to be tried by juries and juries alone.
Well, the right to a jury trial is given to us by the Constitution. And everyone accused has the right to a jury trial in his own case, unless he voluntarily chooses and decides to waive or give up the right to a jury trial and have his case tried to the court or to the judge alone. The judge alone would
Why
make
would somebody
the
want to
decision.
do that, do you think?
Well, among other reasons, because the case is very emotional in nature, very sensational, very disturbing, on the theory that sometimes jurors are distracted and misled by some of the extraneous things in the case, factors like profanity, blood and gore. The theory is that judges, as trained professionals, would be more dispassionate and detached in viewing the facts and applying the law. Those are some of the reasons that we occasionally waive a jury and try a case to the court.
But it's our understanding anyway that the Constitution gives the defendant the right to choose. True? Not true?
The Constitution, neither the Constitution of the United States nor of the state of Ohio specifically says the defendant has the right to choose.
Well, I didn't really mean, what I meant was that you got the right to a jury trial, but you can choose not to do it that way, and this new bill looks like it's doing it the reverse way.
Well, the Sixth Amendment to the United States Constitution, and I believe it's Article 1, Section 10 of the Ohio Constitution, provide for a jury trial in criminal prosecutions. My reading of the history of this is that originally almost all criminal cases were tried to juries. And at those times, the juries and the right to a jury trial was supposed to remain inviolate. The lawyers would argue, of course, to the jury, and then the judge would give their opinion as to the law. But originally, the juries were judges of both the law and the fact. And this was a buffer between the individual and the government. And before the government could actually take a person's freedom or property or life, that the government first had to convince the jury that they were truly guilty and then subject to punishment. The jury was free to accept the law or to reject the law. And the British Crown had one heck of a time early on seizing ships. That was the usual penalty for importing contraband. The Crown was absolutely at a loss of what to do. They even went so far as to suggest that trials were going to then be held in England and not here in the colonies.
Not here in Ohio.
Well, Ohio wasn't Ohio then, but in the colonies anyway, because juries would not convict because they knew that the ship would then be forfeited to the Crown.
I'm going to move my next trial to England.
Yeah, well, then when it came much later in time, when there was the Fugitive Slave Act, where it was a felony to harbor a runaway slave, the juries in the North would not convict, even though the person had supposedly done this horrendous felony of harboring a runaway slave or otherwise facilitating it. We've lost that now, and now juries are instructed that they have to follow the law as given to them, and they've got to swear to this. Where did that change? That changed sometime right after the Civil War, and it became sort of a de facto taking away of part of the jury's function, and this was done by the judiciary. And as a result, there have been many occasions where juries are, I think as Matt pointed out correctly, they're told one thing and then they're shown a whole lot of photographs of very nasty, gory details. And these individuals then say to themselves with almost blinders on, oh my God, I have to follow the law, when in fact, that's not the case. The judges will say different than that, I'm sure, but...
Well, why would, You think that's one of the reasons and it is prosecutor driven, not here in our county, I don't think, although I guess they wouldn't mind the luxury of doing that. You think that's driving, keeping the cases out of judges' hands then, if they don't want them?
Well, most of the times trials are held to a judge anyway. I mean, in a case of most of the trials are misdemeanors.
Misdemeanor
right.
cases, right.
You have to demand a jury trial in order to get one, and you've got to do it within certain time restrictions. Otherwise, you have been deemed to have given up the right to a jury trial. It's only felonies where you actually have an automatic right to a jury, or cases where the possibility of incarceration is 1 year or more. Some of these are strange mixes kind of a misdemeanor and felony. But ordinarily, judges try cases in municipal court day in and day out, and it's sort of rare in those situations for a driving case or a simple assault or a petty theft that you would even have a jury to begin with.
Well, let me get down to maybe some statistics, and I don't expect you to know exactly the statistics, but you get cases, and in your office, I know that you're probably handling what, 20 or 30 at a time, something like that. Would that be a fair estimate?
Sometimes more.
Sometimes more, depending on how much people are kicking up their heels, I guess. So you've got to make a decision when you're talking to the client, and the client's got something to say about it as to whether you want to have a jury trial or a judge trial. What do you feel are the feelings of your unvarnished clients who are suddenly in the hot seat?
Well,
most of them in jail probably too, right?
Very often, yes. I'll tell you, one of the things you have to do is sit down and talk to them about the pros and cons of a jury versus a bench trial. And it is the cases that Matt referred to, the types of cases that a prosecutor can take in front of a jury and cause the jury to hate your client for some reason, whether it be his prior criminal history, something about the particular allegation, whether it's proven or not, whether it's an element of the offense or not, to distract those jurors from the facts of the allegation against him and or her and the law. And it's in those situations where there are times where I tell a client that I think a judge is going to be fairer in your case than our 12 individuals in the community. Even sometimes drug-related cases. We get jurors in common pleas court with the felony level offenses from all over Montgomery County. They're not familiar with drugs. The allegation that somebody, say, is dealing drugs on the street turns them off immediately. Whereas the judges that hear drug cases every single day of every single week are not going to be incensed by the pure allegation. So you need to balance that with your client. Talk to the client about who this judge is and your experience with that judge versus what a jury is going to hear about your client that may prejudice them without having heard the facts or the law in relation to the charge against him. So those are things you need to talk to him about.
And if I may, I can think of two categories that were almost exactly like that. One would be someone who is required to register as a sex offender.
Right.
The minute you mention that in front of a jury, it's over. The second would be not paying child support. Again, juries traditionally don't like it. And so regardless of what the facts are about the particular case, you're running an uphill battle almost immediately. In situations where judges who have presided over cases for years, they're not so taken by the allegations themselves, but they look more to the statute and what facts prove which part or which element of the statute. And in certain cases, that's exactly what you have to look for. There might be no argument on 3 out of the 4 elements of the crime charged, but if you try to argue that to a jury, and they have taken a disliking to your client because of the type of case that it is, they may not listen to you, and they may not listen to the actual instruction given that unless and until the prosecution proves each and every element, you are not to convict.
Which do you think is more important, that one element that you're working on or the likability of the client?
If you're in front of a jury, the likability of the client.
Matt, how do you make your clients more likable?
Well, sometimes you can, sometimes you can't. I've been in the position of telling some juries in the past, you may not like this or that about my client, and in fact, I don't have to like my client to defend him, nor do you, the jury, have to like him in order to acquit him, because a trial is not a popularity contest. And so I'm often very explicit with a jury about setting aside a natural dislike about something that they see or hear. And I share that with them. I say that's perfectly normal not to like this. But we're not here to judge someone's lifestyle or someone's appearance or someone's philosophy. We're here to judge whether what they did matches up with this criminal law, the way it's written. And by and large, when you put it to a jury that way, they will come around and say, yeah, we want to be fair even to someone who we don't necessarily like. I think that's sometimes the way you have to go about it.
I think most folks that get in trouble with the law, and fortunately not as many do as could, I suppose, or maybe they just never get caught. And I know you've all practiced in municipal courts and in misdemeanors. How is that different, approaching the case with prosecutors who have probably just as many cases as you all have, going into Dayton Municipal or Vandalia or something like that, in defending folks who, if it's a misdemeanor, I think experience tells us a lot of times that they may be playing the system themselves besides committing some crimes. So what's the approach, do you think? Knowing the person could very well be guilty, is it minimizing time, getting them to figure, take your medicine now and don't do it again?
Well, I would say the volume of the number of cases in municipal court requires us to be more efficient. And likewise, requires the prosecutors to be a lot more discerning and skeptical about their own cases. In other words, we don't have a lot of time and resources to invest in every case in municipal court. And so both sides are trying to determine how serious this case is, how good the proof is on either side, how much time we can really invest in it. And as a consequence, a lot of these cases get resolved and negotiated pretty rapidly.
Okay. Our floor director tells me we've got about 15 minutes left. We're still waiting for that first elusive phone call. We're at 223-5311, and we'll answer anything. We've been talking about some things, but if you want to talk about DNA or court costs or escape charges or whatever, give us a call. We're talking about criminal law with 3 of the most efficient and well-read prosecutors. Well,
No.
2 out of 3 are pretty well-read.
No, we're not prosecutors.
What did I say? See,
You said prosecutors.
I'm even getting confused.
Now
See?
you're in trouble.
But that just shows that our guests are alert, and that if this was court, they would have objected, and had been sustained, and everything would have been just fine. Public defenders, efficient and doing a great job for their clients. How often do you hear that people say, I want to get a real lawyer, and then go spend their aunt's money on?
Well, if I wanted a real lawyer, I might go to the public defender's office.
There you go.
We
That's
have more
the answer.
experience, frankly, with more kinds of cases than most folks in private practice who practice criminal law. We take about everything that comes down the pike, as Chuck said,
Yeah.
and have to stay current with the law and procedures, and know the judges and the prosecutors pretty well to do our job correctly.
I think the last time I looked, we did, what, 24,000 cases in a year?
I think that was you, yeah.
Yeah,
Well,
right.
does this includes traffic cases?
This
too,
includes
or
this
you could
includes
be
traffic.
jailable.
And that, well, they have to be, the potential for jail has to exist in order for an individual to qualify for a public defender. We don't handle minor misdemeanors where the maximum that you can get is a $150 fine and court costs. We don't handle speeding cases, red light cases, disorderly conduct where it's a minor. We don't handle those sorts of cases. We handle only cases where jail is a possible consequence if convicted. But there are some dockets, Mike, where we have, each of us has been on, where we have handled maybe 120 cases in a month. And that keeps you extremely busy. And in situations like that, the prosecutor has obviously just as many cases because they're on the other side. And there's a real incentive to try to negotiate as many of these cases as possible. We're looking for the best deal, obviously, for our clients if the facts convince us, as they're given to us in the course of discovery, that the prosecutor could, in theory, prove all of the charges.
Now, even though you all approach these cases as lawyers and looking for the legality, you're also human beings with feelings yourselves. What type of behavior are you seeing in the field of criminal law that gives you most cause for concern and a desire maybe to assert some sort of rehabilitation on your clients?
I'll tell you, substance abuse in our community is the #1 cause of crime, and these people are real people with real problems that...
They're not really criminals, a lot of them, are they?
Well, they're not bad people. They may be
Yeah.
people who have committed crimes, but there's always an underlying issue that they're battling with that caused them to make the poor choice that they made. And I'm not talking about the wrongfully accused. I'm talking about the people, yeah, that did it. We need to address why they did it. What was the driving force? What was the issue that they're battling with, whether it be substance abuse or mental health issues or economic issues? And if we can direct them to the resources in our community that can help them, they're going to be much less likely to reoffend if we can truly address their issues. And of course, they're going to have to participate in that.
Well, that's what I was going to say. It takes two to tango in these things, and I know the courts and your offices and the mental health folks are all there willing to help. Do the people who need the help, are they getting into the swing of things?
Some are, some aren't. I mean, one of the things we're battling with is reduced services. We don't have the mental health resources and facilities that we used to have in this community, and that's due to the budget cutbacks. And I know we're all troubled by the many people we see day after day and week after week who do have major mental health challenges, and they're out on the street. A lot of these folks don't have the prescription medications, the counseling, the treatment, various kinds that they need. And some of them are parents, some of them are in desperate circumstances. So that's a real crying need locally, and we're up against that all the time.
Well, and of course, the folks that you're dealing with are in a socioeconomic situation where they're not wealthy. They don't have resources. Does that nonetheless give an indication of what's happening in the higher socioeconomic strata, do you think?
If I'm understanding your question correctly,
Let's see.
are you talking about individuals who are from better families or more well-to-do
Well, not
families who are engaging
necessarily.
in
And we've had this
crime?
discussion before, not necessarily better families, but more
Well-
disadvantaged families. And I think that people who aren't in the category of needing public defender, and Christine talked about this before, as a need for drugs or something, people with better advantages have money to buy drugs or guns.
We're seeing some of that. We're seeing some of the younger people who come from probably more affluent backgrounds, who are unfortunately purchasing and using drugs like heroin. And that is honestly one of the most addictive substances known to man, apparently. And it is something that troubles, I think, all of us when we meet someone who may not have had a bad background when they were young. As a matter of fact, they may have had almost every advantage one could reasonably want, but they will start down the road of trying this sort of drug, I guess, for recreation or to try to impress the friends. And the next thing you know, they can't shake the addiction.
Do you think we're in an atmosphere where there's a certain disregard for consequences based on what you've seen from your clients and the crimes that are committed? And we've talked about drugs, guns, thefts. Are we approaching where folks are just saying, I'm going to do anything we want, and maybe there's nothing that can be done?
Not because they just want to do that, steal or have a gun. They're doing it for a reason, and they're stealing to get money to support a habit, by and large, most of the time. And as Chuck said, heroin does not discriminate. The other drugs out there on the street does not discriminate. Can happen to any one of our children. Doesn't matter where you live. But people, very rarely do you have a thief that's just going out to steal for the sake of stealing.
For fun.
Or for fun, yeah. These people aren't thinking about the consequences of their theft. They're thinking of the consequence of what if they don't get their next fix, because they're going to get sick. Mm-hmm. And
Yeah, they can see about 5 minutes into the future. People aren't thinking about long-range consequences, and some of our clients aren't aware of how serious this is.
Well, I wanted to ask about that too, and we talked about meeting the clients, and of course you get to know them a little bit as you go along, especially in the felony cases, I think, because they take longer. And I know all three of you, and and most of the folks in your office, and you give them a good advice, and part of it is stop doing this and start doing that type of thing. Are they listening? Or are you falling on deaf ears?
They're listening when they're going, and I hate to generalize.
Well, everybody wants to get the best.
Please don't take this the wrong way, because I'm not trying to put everybody into the same box. That's not fair. It's not accurate. But there are some individuals whom you represent, and that's the last time you'll ever have a file opened on that individual. And if the experience is unpleasant enough, the having to interact with the criminal justice system, that's enough for a good number of people. I've had enough. I'm not going to break the law again. But then there are other individuals who are satisfied repeat customers, it seems, and they return.
What's what they do best? Is that what you're saying?
A lot of them, unfortunately, will do it again, and there are some people that you can almost tell that if you can get them into probation, it's going to be about 6 months down the road when there will be a revocation. And with experience, you tend to be able to predict that with a certain degree of accuracy, unfortunately.
And I suppose some of the clients, not only do you all get to know them if they're repeat offenders, but the courts get to know them.
That's not a good thing.
And it's not just looking at the file, but sometimes they recognize
The name.
the face, the
Yes.
personality. Yeah. You know, look over our floor director. How much time do we have? I can't read that. Just give me a couple of fingers here. I can't. We'll be off the air before I find that. And the answer is 2 minutes. Okay, so.
So that was 2 fingers.
Yes. So what I'd like to do, and it's been great having you here. It really is. I mean, after a while, we run out of show here. Any thoughts on whether we're going to get better behavior out of our populace, or whether it's just going to be more and more crime? Are we going for good, or are we just going to be stagnant? And
Well, I think we're always going to have job security, but
not as prosecutors either.
No,
Prosecutors will
no.
always have that.
but I do think that if we can deal with the issues on the ground level, we need to get better school systems, especially in Dayton Public Schools. We're going to need to educate these kids, keep them in school. You know, the DARE programs are wonderful programs in the community. Teach them the dangers of drug and alcohol abuse. Start at the ground level, the socioeconomic communities, teaching young children, and start there.
Okay.
I sometimes say if people ever discover the 10 Commandments, we'll be out of a job.
Thank you, Matt. It's going to be a wrap here. It's been great having you all. Mr. Matt Arntz, Mr. Chuck Grove III, and Ms. Christine Communal, really appreciate having you here. This has been a production of You and the Law. We've been talking about criminal law tonight in the public roles. I want to thank all the volunteers behind the scenes who have made this program possible. I've been your producer and host. I'm Mike Monta. Thank you for joining us. We'll see you again on You and the Law. Good night.